I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
It takes real courage for a judge to stand up to corrupt officers. Today, we'll look at cases where judges ended these cops' careers in under 5 minutes.
The only thing would be officer safety, just the pat down.
In February 2025, a black man was thrown behind bars for absolutely nothing. He wasn't even driving, just sitting in the passenger seat. Yet somehow, that alone was treated as a crime.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there.
It's on March. Not all the cases are open.
One of them's still open. Paul Two's representing him. I talked to Paul yesterday, and it's set for sometime in March. I can't recall the exact
It's okay.
date.
To do probable cause, you have the right to remain silent. Anything you say can and will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex, please.
Yes, Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. Marijuana was 1.27 ounces.
You're telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
The officer's own attorney ultimately sealed his downfall, admitting to the judge that the passenger had no role in the alleged deal. He was simply sitting in the car, yet they still hauled him into court.
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
Your Honor, the only thing would be officer safety, just the pat down.
All right, Mr. Barnes, I'm gonna find no probable cause. Just be careful, all right? Really, you hang with dogs, what happens?
You did.
No. You get fleet. Well, you can get bit too, right? Please,
It's a bad dog.
just don't hang out with the wrong people, all right?
Yes, sir.
Come on.
The judge wasn't swayed by a single argument. He cut through the noise and declared they had the wrong man, plain and simple. This next officer thought the system would protect her, but instead, it exposed her for the world to see.
No permission. No probable cause to search. Okay. Well, why are we still here?
Up next, we have a courtroom moment where an officer is pressed on her decision to conduct a stop, and her answers raise even more questions than the stop itself.
Good afternoon, Your Honor. Abigail Wilson on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Robbins, who is standing to my right.
Today was the date scheduled for preliminary examination on carrying a concealed weapon. Are we ready to proceed?
The people are ready, Your Honor. Thank you.
Yes, sir.
Any preliminary matters before we call witnesses?
Not from the people. Officer Burkett, where are you currently employed?
City Land Police Department.
And what is your job title?
Police officer.
What are your general duties?
Respond to calls for service, self-initiated activity, and officer fighting role.
How long have you been a police officer?
With Lansing, it'll be 2 years and 14 days. And overall, I think I've been licensed for about 3 years.
Okay. Now, were you working as a Lansing police officer on December 12th of 2024?
Yes.
And what was your assignment on that date?
Road patrol.
And what were you wearing while you were working that date?
Full uniform.
And does that have police on it?
It does.
And were you in a car, on foot, or something else?
I arrived in a fully marked car.
And is that department issued?
Yes.
Now, on that December 12th date, you said you were dispatched for a personal injury accident, is that correct?
Yes.
And by that, do you mean a motor vehicle accident?
Yes.
Okay. Now, when you arrived at that location, what was happening?
There was a car in the northbound lanes of Penn, slightly in the road, that appeared to have collided with the curb and then the traffic.
The questioning started calmly, but what came next would flip the entire courtroom upside down.
Were you able to make contact with anybody involved in that accident?
Yes.
Who?
Sierra Robbins, the driver.
And do you see Sierra Robbins here in the courtroom?
I do.
Can you point her out and describe something she's wearing?
She is in the black knitted sweater.
You needed to speak with her?
I did.
What was that conversation?
I can talk to her about her employee notes for a little bit, got her license, and then we did talk about insurance.
And what happened when you started talking about insurance?
To my recollection, I began asking where it was at. She told me the glove box. to my, again, recollection, I said, do you mind? He's interrupted. She said, go ahead. I went into the glove box, and at that point I found a firearm.
And do you remember what kind of firearm that was?
It was a revolver.
Do you recall if Miss Robbins had a CPL?
She stated she did, and she did not.
And were you able to run a law enforcement check on her?
Yes.
Did it come back as her having a CPL?
She did not, no. I had Ingham County run that.
Okay. And did she acknowledge that the gun was in fact hers?
She said that her dad bought it for her under her dad's name.
But she knew that it was in the car, is that correct?
Yes.
This is where it gets intense, as now the defense attorney steps in, ready to dismantle the officer's justification piece by piece.
And you recognize that this is the report that you wrote back on December the 12th?
Yep.
And when you do a police report, do you essentially kind of go off memory, or do you go by like the notes you take on scene, or how do you do that?
All of the above.
And do you remember specifically in this case, did you use all of the above?
Yep, I used my memory and the notes on scene. This report was written shortly after the accident was.
Body cam video on that day?
I was running code there, and so with the way our cars are set up, it automatically turns our body camera on while we're running.
Okay, so your body cam was clearly running throughout this entire situation. Is your testimony today that essentially Ms. Robbins gave you consent to search her glove box prior to you going into her car?
Yes, in the way I perceived it, yes.
Was there another vehicle involved in this?
No, she says she hit the ice back here, and obviously you can see she definitely came up through.
Is this her?
This is her here. Sounds like she's.
Okay. Officer, is it, after seeing this video, is it clear that you actually had contact with Ms. Robbins prior to her being in the ambulance on this occasion?
Yes.
I came from back there. Let me get in the ambulance up and check you out, and I'll come to you in a second.
Okay. With you having seen now your first contact with Ms. Robbins, did she attempt to essentially tell you about the scene, about what happened with the car?
Yes, but I prioritized her injuries rather than a statement at that time.
Okay, so you sent her away to the ambulance.
Yes.
And so there's been no consent to search the vehicle at that point, having what you've seen there?
Then comes the turning point. The defense attorney plays the body cam footage, and the officer's actions speak louder than her words.
And officer, is that you opening the car door, opening the glove box, and starting to pull materials out of the glove box?
Yes.
Okay. And then officer, is that you proceeding to essentially kind of search through the center console of the vehicle at that time?
Yes, but not for any criminal reasons.
So you said not, you searched the console, you said?
Yes, I only search the places that are people most commonly hold their insurances.
Okay. Okay, and that would be the moment that you found the firearm in the glove compartment?
Yes.
So after, I guess, seeing this video, is it now your testimony that you did not speak with Ms. Robbins at the ambulance prior to going into that car?
Correct. After seeing this video, it is refreshed, yes.
And it is also your testimony that you had no probable cause of a crime being committed on scene?
Objection, Your Honor, that is a legal conclusion.
Your Honor, I'm asking what her reasoning to search the vehicle.
No, she can make a determination as to whether or not there was probable cause to search.
It is our policy and procedure that whenever there's an accident, we get license, registration, proof of insurance.
The question is whether or not you have probable cause to search.
No.
And based on the video you've seen now, you did not receive any consent from the driver to search those areas of the vehicle, is that correct?
Busted. No matter what she was after, this cop had neither probable cause nor consent to search, and the body cam proves it.
And this video was a fair and accurate representation of what went on?
Yes, this is what happened.
Then, officer, at some point after this, you go and speak with Ms. Robbins in the ambulance, make sure she's okay at that point?
Yes.
And then she was released on scene?
Yes.
No further questions, Your Honor.
I didn't read it right.
Thank you, Your Honor. Officer Burkett, do you know what happened with the vehicle after this accident?
I don't recall.
Okay. And are you aware of any requirements that individuals carry insurance when they're operating a vehicle?
Yes, it's law.
Okay. And you said, I believe on cross, that it's routine for your department to ask for that insurance. Is that correct?
Yes.
And was that your purpose in going into the car, was to confirm that there was in fact insurance?
Yes, if she's being evaluated for an injury, there's a chance this vehicle is gonna be towed.
Well, strike that. There's no question. You know, but I have a question now.
Yeah.
Because maybe I missed something. You testified on your direct that she gave you permission to go in the glove box. She told you that the insurance was there.
Yes, this was prior to being arrested.
Okay, so the video we show is accurate that she never told you that she had insurance in the glove box.
Right.
And so you went and opened the door without her permission.
Right.
And went in the glove box.
Right.
And then went in the center console.
Right.
No permission.
Right.
No probable cause to search.
Based on the testimony here today and the evidence, we are at this point not requesting bind over on this charge. Thank you.
Case is dismissed. You're all set. We'll get you a dismissal.
And just like that, the case was dismissed. How many lives get destroyed by lies like this? They write one thing in the report, swear to another in court, and then crumble the second video evidence appears. Absolutely shameful. This officer's arrogance quickly crumbled when the gavel came down harder than expected.
I took photos of a female that I arrested.
Why would you plead no contest to a charge of disorderly conduct for having done that?
I guess I broke policy and...
In 2014, Officer Brian Pergandy was accused of disorderly conduct after snapping disturbing close-up photos of a woman he had once arrested, and now he was about to face the consequences.
Pergandy, if you give up all those rights today and thereby give up the right to have a trial, there's never going to be a trial in these matters, sir, and instead we are going to resolve it all here this morning. You understand that? Mr. Pergandy, you're joining with your lawyer, sir, and pleading no contest to this disorderly conduct charge back from September the 8th, 2009?
Yes.
What is it specifically that you did that you're causing you to plead no contest to disorderly conduct here today, Mr. Pergandy?
I took photos that were eventually blown up, I believe.
What?
I took photos of a female that I arrested.
Why would you plead no contest to a charge of disorderly conduct for having done that?
I guess I broke policy and I guess I made her feel uncomfortable, Your Honor.
Why would you have made her feel uncomfortable, sir?
I don't know. She was fully clothed.
The judge wasn't about to let this slide. He grilled the cop and escalated the charges to a felony trial. He came in thinking he was untouchable, but the judge wasted no time reminding him he wasn't above the law.
Found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter. Assessed his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12...
In this next case, justice comes knocking for Aaron Dean, a former cop who shot an innocent woman through her bedroom window, and he's finally facing the consequences. And now, he's about to be charged with one of the most shocking and senseless murders you'll ever hear about.
Verdict reads, we the jury, having found the defendant Aaron York deemed guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Verdict. Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much. Mr. Gill, Mr. Brissett, is there any legal reason why sentence should not be pronounced?
No legal reason.
Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Is there an allocution? You may be seated. Thank you very much.
After all that, Dean escaped a murder conviction and was sentenced to just 11 years for manslaughter, and many say that's a slap on the wrist for such a shocking crime. The courtroom quickly turned into a lesson in humility when this officer realized the badge doesn't shield you from justice.
By felony of armed criminal action I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections.
On December 3rd, 2019, a call about a man chasing his girlfriend ends in tragedy. As the suspect pulled into his driveway, Officer Eric DeValconaire ordered him to step out of the truck. When he didn't comply, DeValconaire fired twice, killing him instantly. What followed was a murder charge and a trial that kept everyone waiting for the verdict.
No matter what I hear, I will only consider factors that are appropriate and that I will disregard those that are inappropriate. And that is what I've done here, and as a result, I've concluded as follows. There are a number of facts in this case that are both aggravating and mitigating, sometimes all at the same time. First and foremost is this undeniable and uncontested fact. Cameron Lamb is dead, and Eric DeValconaire killed him. That's undisputed. Cameron Lamb was by all accounts a helpful and loving son, brother, father, and friend. People who have contacted me and who I have heard from today have described him as funny, caring, giving. Miss Gray called him a protector, a jokester, and my favorite of all the ones that I read, not a saint, but our angel.
The judge wasn't playing around, as he recognized that the victim had done nothing wrong and that it was the officer who committed the terrible act.
His death leaves an irreparable and unfillable void in the lives of his family and his friends, and also in our community. Also, as I'm weighing all these facts, it can't be overlooked that the offense of December 3rd of 2019 were initially set into motion by Cameron Lamb in his decision to chase his girlfriend through city streets at dangerously high speeds, putting motorists and other members of the public at risk. However, those events tragically concluded with the actions of Troy Schwam and the defendant. Sergeant Schwam pulling into the driveway, immediately getting out with his weapon drawn, rapidly moving into the backyard, carport, garage area of the house, and defendant doing the same. Both without taking a breath, without pausing for the briefest of moments to consider where they were going, what they would find when they got back there, whether they were acting lawfully in doing so, and whether there might be some other safer option, without so much as a, "Hey Troy, wait."
The truth was undeniable. Cameron Lamb wasn't even reaching for a gun when the officer pulled the trigger. The judge laid out every detail as the disgraced cop sat there.
At any point, Sergeant Schwam and the defendant could have done this. A fact that is made even more aggravating as the court considers an appropriate sentence in this case by the fact that the one person who ultimately did take a breath that morning was Cameron Lamb. He did this when at some point, while he was chasing his girlfriend, he decided to discontinue the chase and to go home. The video from the helicopter shows this decision, shows how it played out. Cameron Lamb is not racing through the streets of his neighborhood at this point. He's not driving through yards to get away from anyone. He does not abandon the truck and let it roll into someone's yard while he flees on foot. Rather, he simply pulls into the driveway of his home, pulls around back, puts the vehicle into reverse, and slowly begins backing it down the driveway under the carport and into his garage. Sergeant Schwam and Eric DeValconaire arrive, and as the court has found, an encounter that was over and a situation that had de-escalated was again escalated by what I have found, rightly or wrongly, was their unlawful entry into the backyard carport area and confrontation of Cameron Lamb. This is an aggravating factor. Cases of the offenses described during the trial, however, also provide the court with a mitigating factor. I found, as I've considered the evidence in the case, that the defendant, Eric DeValconaire, testified credibly at trial that he was rushing to provide cover for Sergeant Schwam, who had rushed into the backyard with his weapon drawn, prompting the defendant to do the same from the other side of the house. Although not in the court's view, again, rightly or wrongly, negating his obligation to act with reasonable care, as the court found he has failed to do.
This wasn't policing, it was tyranny. Officers overestimating their power, invading a home illegally, and leaving an innocent man dead in his own home.
Natural reaction to protect his partner is a factor for me to also consider. And let's also be clear, and it is hard to accept this distinction. I know that. Murder and involuntary manslaughter arising from criminal negligence are two different things. They are different legal concepts. They are different things. Eric DeValconaire is not Derek Chauvin, who murdered George Floyd. Eric DeValconaire is not one of the 3 men in Georgia convicted of running down and murdering Ahmaud Arbery. This is a mitigating factor. Defendant has no prior criminal history. His ORAS scores him as a low risk in all categories. Defendant's history as a police officer, husband and father, friend and colleague is also a mitigating factor that I have taken into account, as his father asked me to do, which I was already going to do, and that is to consider the totality of the circumstances and to consider the totality and the circumstances in the history of defendant's career and his life that have been presented to this court have demonstrated he has not hesitated to immediately take action when he believed the circumstances surrounding him warranted it. And this trait has generally served him and others well. It also failed him, as it did on December 3rd of 2019. All of which, however, leads the court back to where it began, an evaluation of the impact of the defendant's crime on Cameron Lamb and his family.
What made this case sting even more was the judge's decision to side with the suspect, despite the evidence pointing to yet another clear-cut killing.
Cameron Lamb is dead. Eric DeValconaire killed him. And the court has found that that happened because the defendant acted without considering or being aware of the substantial and unjustifiable risks associated with his conduct, and that his actions were a gross deviation from the standard of care that a reasonable person would exercise in the situation. Having concluded, as I have, having considered all those factors, I ask counsel if there's any legal reason or cause having been shown why sentence and judgment of the court should not now be pronounced. Eric DeValconaire, on count 1, the Class E felony of involuntary manslaughter in the 2nd degree, I sentence you to a term of incarceration in the Missouri Division of Adult Institutions of 3 years. On the unclassified felony of armed criminal action, I sentence you to a term of incarceration of 6 years in the Missouri Department of Corrections. Those cases, or rather those counts and sentences, will run concurrent with one another for a total term of incarceration of 6 years.
Eric was found guilty of murdering Cameron Lamb, yet he walked away with just 6 years. The reduced sentence makes one thing clear: he was protected because he was a cop. Moving on, watch how this evil cop was rightfully punished and sentenced in court.
You were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't shoot me, man, I don't want to get shot," right?
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes.
And then you told him to put his hands on the dash, is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Fallen, yes.
And then the other officer with you on the other side of the vehicle changed that to put your hands on your head, correct?
That's correct.
They did all that and didn't investigate anything. Humanity and basic human decency were not in these cops' dictionaries.
Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was talking to you, he was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
She's asking these questions to make it clear that Floyd wasn't drunk, sick, or had medical issues. While he was talking to them meant that he was sane and posed no threat.
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
You were asking questions about what the other officers were doing, correct?
That's correct.
your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop dead while you were interacting with him, correct?
No.
Thank you. Nothing further.
Basically, two officers at the scene gave two different commands to Floyd, hands on the dash and hands on the head. He can only do one, so they used this trap to drag him out. Eventually, this cop was sentenced to 21 years in prison. This officer certainly earned his karma, but things took a bizarre turn when this next cop's qualified immunity was revoked.
He had nothing in his hands, and he was shot twice and
A routine traffic stop in 2011 ended tragically when Officer Osvaldo Villarreal fatally shot Benny Herrera, an innocent man. Years later, Herrera's family sued the officer, and this video documents a pre-trial hearing related to that lawsuit.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping
But if we're
backwards.
talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Shooting man in seconds? Cops these days really don't have the guts to investigate. They are so scared out of their minds, everything seems like a threat.
His camera was turned on, but he testified.
His camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
And to top it all off, his PD cleared him of any wrongdoings. The system does support corrupt pigs, or else this one should have been fired that exact day.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make
Well,
that
don't we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
The body cam footage made it very obvious that the officer was in the wrong, and the judges also felt that his qualified immunity needs to go.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. How is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Villarreal got off easy, basically. No real reason for the shooting, but he's still on the force. Go figure.
It seems like he had a better vantage point possibly than Mr. Villarreal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the fact as alleged by the plaintiff. And
Right.
they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
But this tyranny wouldn't last long because the expectations of the victim's family were high.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, if we take those facts, you're saying that as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed. But that's not the same thing as saying he wasn't armed.
The judges argued that the officer should at least be tried, as the other party had substantial evidence to challenge his qualified immunity.
Espinosa, the suspect, had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The defense tried everything, but the judges weren't having it. At least he didn't plead insanity like all the other cops do.
Here, the domestic violence incident was over.
Yes, and there.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
Fully on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
And both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Villarreal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The cop had no need to escalate the situation. He could have just taken a chill pill and relaxed himself and the people he was supposed to investigate.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Both hands were visible, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
The judges couldn't be blinded so easily, and they couldn't overlook the fact that Herrera was dead, and Officer Villarreal was the only one responsible for the sad death.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean So depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial, the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point, if we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
at that point, I got the answer. Right.
Finally, some justice for Herrera. Officer Villarreal's qualified immunity was revoked and a trial took place. The court ruled that he had used unlawful deadly force. The city also paid Herrera's family $1.4 million in compensation as the case proceeded to trial. This next sorry cop was also being questioned for excessive force.
Did you apprehend good guys?
Objective form.
Never. I take that back. I bit a victim one time because she jumped in front of me.
Do these cops not have any trigger discipline? Daytona Beach PD officer Joshua Mercereau was in a gunfight with Marvin Jones. Jones got hit 5 times, and his girlfriend, Aviana Bailey, got caught in the crossfire. She's paralyzed from the chest down now, so she's suing.
Playing, fumbling, doing something in his lap. There's none of this, there's none of this, it's this. And he's looking at me the whole time. And then it happens. What happens?
He sticks the gun out the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would my... So he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving...
Exactly.
I'm sorry. If I'm driving, the driver's side is... The door is here. So he did this.
Okay. Because you had him moving...
Excuse me.
...further into the passenger compartment.
No, that was completely...
Right.
That was my mix-up in the side. It was the right side that he did it with, and then he put the gun between the window.
Officer Joshua couldn't even get the story straight. All of his memory issues are going to pop up right now.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No, okay. I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least one, and possibly 2. I can't count them. I can't tell you how many exactly I saw.
The man shot a guy 5 times and sat there like he was at a coffee date with his friend. He showed 0 signs of remorse.
I was committed to engaging him, and I did that. At which point, my ankle rolled off the curb, and I fell on my back.
Okay.
I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. Fired at you, or you saw several muzzle flashes?
Yes.
Okay. How do you define several?
Objective form.
1 or 2. 2 probably.
Okay. Several's not 1.
Yeah.
We agree to that. Do you mean is several more than 2?
Objective form.
I would say 2.
Okay.
So we'll say a couple.
Okay.
Investigators pressed Joshua about the tragic incident, but he continued to make light of the serious situation, attempting to joke instead of addressing it responsibly.
In your deposition, you discussed dust. Tell me about that.
Form.
Was there dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene too.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? That's what we say. Before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Objective one.
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua had no remorse for his actions, and as the deposition continued, his answers were about to get even more weird.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Objective one.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on his, making very furtive movements.
Okay.
The attorney then questioned Joshua about his troubled past, which included being removed from his role as a canine officer.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me.
Because your dog got him?
Because we got them as a team.
Okay.
If you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
This cop was downright dirty and arrogant. These are exactly the kind of people you don't want on the force.
When was your canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Why does that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Objective one.
Never. I take that back. I bet a victim one time because she jumped in front of me. So I did. I bet a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's history was riddled with poor decisions and excessive use of force. The attorney dug deeper, exposing his psychopathic nature.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
There was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did.
No.
The one of them.
The one of them had a felony warrant.
The guilty one, not the
yes.
innocent one.
So the mother's there, and we got the place surrounded, and basically she said, "You're not coming in." Well, he's in there. We can see him in there. We can force entry on a felony warrant. I eat that one. That was my responsibility all day long, for not knowing that it's the brother. They do look different. If I had seen his face, maybe pay attention to his haircut.
Did you ever arrest a good guy?
Form.
Did I ever arrest a good guy?
Yeah.
Not that I can recall.
Qualified immunity swooped in and saved the cop naturally. Bailey got some cash, but seriously, that's supposed to make up for being paralyzed? Well, that brings us to the end of this video. Today, we witnessed corrupt cops being held accountable.
Thanks for watching. Please support the channel by subscribing and leaving a like. Also, if you enjoyed this video, check out the next video here.